Fair Lady. I come on then to English law, and the first submission, which needs no authority, but it is that an assignment of rights carries rights and not obligations. And if I can just invite you to look at one illustration of that, which my submission would extend to cover this case as a matter of general principle. It's in the Pan Ocean case at page 750 of the electronic bundle. It's in the Primary Authorities 1 tab 12.
It is, of course, perfectly possible to have an assignment of both rights and obligations. It happens all the time.
It is.
When debts are assigned, they carry with them the obligations that go with those debts, and so on and so forth. That's very common. But I suppose it depends on the interpretation of the particular assignment, does it?
But this assignment is rights only. My learned friend read it out to you.
Yes.
So perhaps I should adjust my submission that an assignment of rights only is an assignment of rights only when it becomes a bit tautologous.
It does.
But this, my learned friend read it out, and this is an assignment of rights only. But the consequences of that can be seen, I submit, at the Pan Ocean case in the House of Lords at page 750 of the electronic bundle. This, just to tell you the facts, this was a fairly common case of a ship owner assigning the right to hire to a bank. And what happened was that, as is usual on the normal form of time charter party, hire is paid in advance, subject to an express promise to repay any overpaid hire. And what happened was that the assignee asserted its rights, sent a notice saying, please now pay the hire to me as assignee, and that was done, but the hire was overpaid, and there was a question of repayment, both contractually, but also it could have been framed as a restitutionary claim. And the House of Lords unanimously held, as we see at page 750 of the electronic bundle, at the very bottom line against the letter H, there is no justification for subjecting an assignee because he has received a payment in advance to an obligation to make a repayment because of the non-performance of the event for which he had no responsibility. And when and if this comes to be tried, of course, that is going to be a complete answer to the actual claim on the merits, but that doesn't arise today. But what their lordships went on to do is to consider the benefit and burden principle of the Vice-Chancellor in Tito and Waddell, which has given rise to much academic analysis. But at the letter E at page 751, the statement of principle by the Vice-Chancellor only helps Mr. Hurst if credit corps' right to receive payment in advance was a conditional benefit, a conditional right, or what the Vice-Chancellor describes as a conditional benefit. In fact, the right was not conditional. So the general rule is that there can be no obligations, and the obligation would extend not only, or the point would extend not only to an obligation to repay, but an obligation to submit to a claim under a jurisdiction clause to repay, as is done here, unless there's a condition. And the question of English law in this appeal is, well, what is the condition in a case where there's an assignment of a right to pay under an insurance in circumstances where there's a jurisdiction clause in the policy? And my submission is that English law is that the only condition is that the assignee is not entitled to assert its claim inconsistently with the terms of the contract. And my submission following on from that is that there's only inconsistency if you sue contrary to the terms of the contract, and not if you write a letter saying, please pay if that's what we did. Now, for that, may I actually cite you the leading case on this, which is referred to in all the cases that my learned friend did cite to you. It's the J. Bowler, Detlef von Appel, I think, against Vost Alpine at page 753 of the bundle. That's Principal Authorities 1, tab 13. And that is the first page of it. And just to tell you the facts, the insurer of the charterer acquired by what was equivalent to subrogation the charterer's rights to sue the ship owner or the carrier. But in the charter party, there was an arbitration clause. And the question was, when the insurer sued directly in the Brazilian courts, would the English court prevent that on the basis that of the arbitration clause in the voyage charter which the insurers had acquired the rights to? And the answer was, in substance, yes. And it's page 760 of the electronic bundle, where the principle is stated. In the left-hand column, having considered authorities, including his own in the Jordan Nikolov, which my friend did show you, against the dark line at 286, I will point out the salient features of this. The rights which the insurance company acquired are rights which are subject to the arbitration clause. The insurance company has a right to refer the claim to arbitration to obtain an award in its favour if it can. Now, the whole issue here is enforcing, inserting, but it's all about the procedure, the forum. In no other sense is the word make any sense. And then it says, award in its favour from the arbitrators and enforce the obligation of a time charter to pay that award. Likewise, the insurance company is not entitled to assert its claim inconsistently with the terms of the contract. One of the terms in the contract is that in the event of dispute, the claim must be referred to arbitration. The insurance company is not entitled to enforce its right without also recognizing the obligation to arbitrate. In every following case, that is the principle that is being applied. In all of the cases in my learned friend's skeleton, in all of them, it is the inconsistency principle, and that follows from the conditional benefit analysis in cases such as the Pan Ocean case, which is you don't transfer obligations, but you transfer a right subject to condition. And the condition is you mustn't break the contract that you've acquired, that you've taken an assignment of. And so, for example, in my learned friend's case of Yule, which he cited at page 767 of the bundle, that was the case of the assignee suing in the courts in Louisiana, contrary to a clause in the assigned contract. And all the discussion there about not making a claim is based on the not making a claim inconsistently with the contract that's been assigned. And of course, by suing in Louisiana, you do make a claim inconsistently with the assigned contract. But by writing a letter saying, please pay, you don't. Because a jurisdiction clause does not stop you writing letters saying, please don't, please pay rather. And I would like, that applies to all my learned friends' cases and all the cases cited in our outline. Most recently, a case called the Yusuf Sepnioglu at page 1572 of the bundle. I won't refer to that, but the passage is at page 1577. But there is one case that my learned friend did go to, and that's the one that starts at page 562 of the bundle. That's Plaintiff's Principal Authorities 1, starting at page 562. And this is the Flag Evie case before Mrs. Justice Cockerell, or Miss Cockerell QC, as she then was, but not for very long thereafter. At page 566 of the bundle. And this is an appropriate moment to note the difference between shipping cases, bill of lading cases, and insurance cases, because in the left-hand column at 566, the court will see the terms of the Carriage of Goods by Sea Act 1992. And the point about this act is that under section 3, quoted in the middle of the left-hand column at page 566, is the heading Liabilities under Shipping Documents. And then it refers to Section 2, subsection 1, which is persons becoming holder of a document. So where that act applies, and the person to whom rights are vested by virtue of that subsection A takes demand or delivery, ... then after B, that person shall, by virtue of taking or demanding delivery or making the claim, become subject to the same liabilities under the contract as if he had been a party to that contract. So whenever you're reading a bill of lading case, if I may put it that way, a carriage of a shipping case, the point is that the person in the position of the assignee is by virtue of statute subject to the liabilities. And it's in that context that Her Ladyship in this case referred to, well, if you make a demand, you're subject to liabilities, but that does not apply in our case. And Her Ladyship then at the bottom of 566, paragraph 40, sets out what I submit is the ratio of the case. And can I just invite you to look at subparagraph 3 at the bottom of electronic page 566, over the page into 567. She applies the J. Bowler, and as she says, as Lord Justice Hobhouse said in the J. Bowler, the insurance company is not entitled to assert its claim inconsistently with the terms of the contract. One of the terms of the contract is, in the event of dispute, the claimant must be referred to arbitration. It were tedious to do so, but that is the principle that is applied in all of the cases following the J. Bowler. Now, there is one case which I would like to refer to, which is not in the electronic bundle, and it's in the supplementary authority bundle, because this is a recent example of what I submit is the same principle, and it is the case of Airbus in the supplementary authority bundle. I'm afraid you have this in hard copy only. Sorry.
Well, was it sent I think it was sent, wasn't it, recently to the registry?
I hope it was,
yeah.
my lord. That was certainly the intention. It's in a slender white bundle which has 3 tabs. And it's page 20.
The bundle isn't slender. The bundle is extremely inconvenient. The contents, however, are.
I suspect that the chooser of the bundle feared that there may be more, and mercifully there isn't. The facts were, although they don't matter, that Airbus sold an aeroplane through various complicated dealings to Alitalia, and it was defective. And Alitalia assigned its rights under its contract with Airbus to its insurers, the Generali and others. And the insurers sued Airbus for the defects, both in contract, but they thought better of that, because that would clearly bring the arbitration, the jurisdiction clause with it, and also in tort under their transferred rights. I think it was subrogation. And the question was whether the fact that it was an action in tort instead of contract was a matter of distinction from the principle that they could only sue in accordance with the jurisdiction clause. So it was an action in Italy, and an application was made in the English court to prevent or to make declarations in respect of the action in Italy on the basis of the clause. At page 37 of the bundle, 76 of the report, as is entirely orthodox and the case, paragraph 93 of the report of the Court of Appeal, the Court of Appeal recite the judge, Mr. Justice Coleman, and the judge, Mr. Justice Coleman, summarized or applied the J. Bowler. And if you see within Lord Justice Males's paragraph 93, Mr. Justice Coleman's paragraph 71, in the middle of that paragraph, the owners have asserted that they require arbitration, and the insurers have refused to accede to that requirement. They have thereby acted and continued to act inconsistently with the owner's equitable rights, and although not a breach of the agreement to arbitrate, it gives a right to an injunction. So it's once again an application of the inconsistency principle, and at paragraph 95, His Lordship refers to the J. Bowler and West Tankers and the procedural availability of an anti-suit injunction. And he says that does not affect the analysis that the English arbitration or jurisdiction clause gives right to an equitable right enforceable against the subrogators, the insurers who seek to act inconsistently with the clause. And that's unaffected by the further rights. And then he refers to Lord Hoffman. And then in paragraph 96, His Lordship says, in my judgment, the House of Lords implicitly approved the reasoning of Coleman J. on the point, but in any event, I would do so now. Insurers exercising rights of subrogation to make a non-contractual claim are bound by a jurisdiction clause to the same extent as the insured, whereas the commencement and pursuit of proceedings contrary to the terms of the arbitration or jurisdiction clause by the insured would constitute a breach of contract. The commencement and pursuit of such proceedings by insurers constitutes a breach not of the contract but of an equivalent equitable obligation which the English court will protect. The whole point of this whole line of authorities is it is preventing, the principle is prevention of acting inconsistently with the clause when asserting or enforcing your rights. And that principle is only engaged if the assignee sues other than in the chosen court. And for my learned friend elides or interprets the words assert or enforce, which are sometimes used, taking them out of context of the cases in which they sit, which are all to do with an assignee suing in the wrong court. And says, well, it applies to assertion or enforcement short of suing, but that is wrong as a matter of context where he finds the words, and it is impossible as a matter of principle because unless you sue, you're not acting inconsistently with the clause. Now, my learned friend then relies on Miss Ambrose, and he read it out to you. Miss Ambrose was making a proposal as to what the law should be, and in my submission, her proposal, tentative as it was subject of disapproval in the Nishin case, and that's page 731 at 733 in the Principal Authorities tab 11. At page 739, I beg your pardon. 731 at 739. 733 was the head note, which makes the same point. But paragraph 47, the arbitrators refer to an article by Claire Ambrose entitled "When Can a Third Party Enforce an Arbitration Clause?" And His Lordship describes that as an interesting contribution and refers to certain of the arguments there in section 8.1. And then at paragraph 48, there's this. The problem with this approach is that it ignores the assignment analogy, which I've explained. The effect of section 1 of, and we're talking about the Third Party Act, is analogous to a statutory assignment to the third party by operation of law to reflect the conditional benefit approach attaching to the right of action, thus transferred the means of enforcement of that right agreed between the parties. Their agreement is effected by limiting the third party to the means of enforcement available to the promisee. And then he goes on to say that that is obviously a reference to the arbitration agreement. And at the bottom, in this sense, Section 8 does indeed fulfill the purpose of giving effect to the mutual intention of the parties to the contract as to how their obligations are to be enforced, and the purpose of rendering conditional the benefit which by virtue of Section 1 has been transferred to the third party. But the whole discussion is in the context of the value of the enforceability of the arbitration clause, and the point His Lordship is there making is the point that I'm making, which is that the arbitration clause only binds, in any sense, as being a condition on enforcement. And it is not a departure from the J. Bowler case. The same applies to my learned friend's reliance on the article of Mr. Joseph in his book. The point Mr. Joseph was making was that in cases of negative declaratory relief, whether or not the assignee has sued or not, or acted inconsistently, there's a case for saying that the assignee is bound by the arbitration clause. But in my submission, that proposal would really be going beyond the authorities and inconsistent with the general principle that an assignment does not convey obligations, or an assignment in this form doesn't convey obligations. And there is simply no basis, if the assignee doesn't do anything, and I would submit doesn't sue, for holding the assignee entitled to rely on the jurisdiction clause to claim a negative declaration. And as the Court of Appeal said, the negative declaration case is different and doesn't assist in this context.
Just on that, I did wonder whether if the assignee is sued for the negative declaration and then wants to defend itself in those proceedings, whether in defending itself it is in substance then putting its case to the jurisdiction of the court which is invited to give the negative declaration, whether that might attract the principle that you've mentioned.
That would, my lord, but the reason for that would be that either because he, in old language, he entered his appearance in the action to defend it without relying on the jurisdiction, well, so without relying on his domicile in Europe. But if he wished to counterclaim for his assigned rights, then the counterclaim would be the subject of the J. Bowler principle. And so the answer to your lordship's question is he may elect to waive his Article 4 rights.
So I suppose the primary answer you would give is his answer to that, if we're within the Brussels recast regime, is just to enter a plea, you've got to sue me in my state of domicile.
And with all due respect to Mr. Joseph's tentative suggestion, what would the answer to that be? There would be no answer. And there would be equally, I submit, and this is where we slightly part company, there would be equally no answer if the insurer, if the assignee had previously written a letter saying, please pay.
Sorry, the assignee had said what?
Had previously written a letter to the debtor saying, please pay. And if the debtor then sued in England for the negative declaration, my learned friend would say that by writing the letter, please pay, he's lost his Article 4 rights. But that's not what English law says, and if it is what English law says, it's not what EU law permits under the succession of obligations principle. So I think, having gathered my thoughts by talking, I think my answer to Lord Sale's question is, firstly, if he doesn't want to sue for his rights, he would simply say Article 4 Brussels. And if he did want to sue for his rights, then he'd have to counterclaim in the action. Because
or if he wanted to establish his rights, so he doesn't actually have a claim for money or something, but he wants a definitive court ruling that he has a good defence, he would have that option.
Yes.
And if he's going to exercise that option and not just rely on his Article 4 right,
yes,
I think you're accepting that he would be bound by the conditionality principle then.
Yes. Yes. But what would bind him is the counterclaim for his declaration.
Yes.
The positive assertion in the proceedings that he had the rights that he claimed. Sorry, my lord. Now, my learned friend prayed in aid the idea of that there might be undesirable consequences if I am right, in that there may be an action against the assignor, or between the debtor and assignor, to which the assignee could not be impleaded so as to achieve what Lord Hoffman was wont to call one-stop adjudication. But that is the inevitable consequence of commercial relations where some parties are and some parties are not parties to jurisdiction clauses. And that, if it's an undesirable consequence, is the result of that fact, and it happens quite frequently. Conversely, if my learned friend were right, there would be, I'm tempted to say dire consequences, but that might be putting it too high, but there would be very inconvenient consequences for those whose business is lending on security and who take assignments as part of their security for the loan, because what my learned friend's submission would amount to is that the assignee, merely by writing a letter of claim, he would say that's asserting or enforcing, would be subject to the obligations in the contract, even if he didn't sue, and even if he had not otherwise acted inconsistently with the contract. And so, for example, in this case, as we'll see happened in one of the other cases that will be subject of entertainment tomorrow, if there had been a very small insurance claim in the first month of the policy, and my client, the bank, had said, please pay that very small insurance claim in the first month of the policy, takes the benefit of it, then, according to my friend's case, it would be liable for all the outstanding premium for the rest of the policy year, and would submit to the jurisdiction clause for all conceivable claims that the debtor, the assignor, the debtor had against the assignor. And that would require banks to be very, very on their guard when asked to write a letter, such as the letter my client wrote here, which my learned friend characterizes as please pay the claim to the broker. I characterize as if you're going to pay a claim, then paying the broker will get you a discharge. But writing that sort of letter will open the floodgates to banks being liable for all the obligations in the assigned contract. And therefore, in the realm of inconvenient consequences, my submission is that the insurer's regime creates far more inconvenient consequences than the submissions that we make. The last issue in this area is whether my client did or didn't enforce or assert the claim if we are wrong and enforcement or assertion short of litigation is relevant. And there in my submission, the findings of the Court of Appeal determine the case on the facts against my learned friend for two reasons. Firstly, as I read out earlier on, and I submit, their findings were that the letter was not presented by the owner on behalf of the bank. It was provided by the bank to the owner, but for the owner's use in its own behalf. And that finding is not the subject of appeal. That Court of Appeal finding is not the subject of appeal. And secondly, in my submission, the Court of Appeal and the judge were right in their reading of the letter itself. This is an independent and separate point. The reading of the letter itself, which is in CV2 at page 417, my learned friend showed it to you, it is not a demand for payment. It is an authorization to pay all claims of whatsoever nature, the first paragraph, and an agreement that payment shall be discharge of the amounts paid. So it is stating if you wish to pay, you can get a discharge by paying Willis. Now, where the commercial judge and the Court of Appeal has so construed it, it certainly doesn't raise any point of law of a sort normally suitable for this august court. There's no basis for overruling the finding of the judge in the Court of Appeal as to the terms of the letter in context. And this court hasn't been treated to the context as were the judges below and the nature of the negotiations. So on this very uninteresting point of, it's actually a question of fact. I maybe submit that. It's although it's a question of interpretation of the letter, it's actually a question of fact on whose behalf it was presented and whether it's a demand or not. This court should, I invite this court not to interfere with those findings, and if considering the matter afresh because permission has been given, I invite them to agree that that is a letter of authority, not a letter of claim or demand. And before leaving this, I do remind you that having travelled to the end of my submissions as to English law, that the ultimate question is whether in EU law there has been that clear consensus clearly expressed, or within the EU law permission to refer to national law, whether the national law provides for succession to the obligations in Tilly Russ, and it on any view hasn't. My lady, that's what I was going to say on issue 1, and then I'm going to come to issue 4 unless there's more. Issue 4 is whether the restitution claim, in this case, is a matter relating to tort, whereof the harmful event took place in this jurisdiction. And where this point fits in, I think my learned friend explained it, but where this point fits in is as follows. If my learned friend is right about issue 1, he does not need this point because he's got a jurisdiction clause. But if my clients are right about the issues tomorrow, 2 and 3, this point will not avail him, because if the matter is covered by the insurance section, if it's a matter relating to insurance, then it's common ground that he's not allowed to avail himself of Article 7, sub-Article 2. And the question is primarily one of interpretation of the article itself. So can I invite you to look again at that? It's at page 792 is where the regulation starts, but the relevant page is 798 within Primary Authorities 1, tab 15. And the context in which Articles 7, 1 and 2 are to be interpreted is Article 4.1, which immediately or shortly precedes it. So this regulation dealing with civil and commercial matters provides the prima facie rule of domicile of the defendant. And then 7.1a, in matters relating to a contract, that there's a special jurisdiction in matters relating to a contract in favour of the place of performance of the obligation in question. And in 7.2, in matters relating to tort, delict or quasi-delict, in the courts for the place where the harmful event occurred or may occur. And there is no suggestion there that 7.1a and 7.2 comprise an exhaustive and exclusive definition of all civil and commercial matters. If that is what they do provide, then Article 4.1 is a waste of ink, because every case will either be within 7.1a or 7.2. And so the misinterpretation, I submit, that my learned friend presses on the court based on Calfellis is one that writes out Article 4.1. It would not have been necessary to state that.
Well, except that 7 is permissive.
It is permissive, but that takes away the shall in Article 4.1.
Yes, because 4.1 is mandatory
Yes,
on its terms, and the derogations thereafter, which are permissive,
yes.
are to be interpreted restrictively. We're told that repeatedly.
That was to be my second point, my lord. But the point is that to create a mandatory rule and then to have a permission 2 articles later, which takes away all content from the mandatory rule, is an unlikely. So that my Lord Kitchen's point that it's permissive, and I think my Lady Hale's point was to the same point, is that one is construing 7.1a and 7.2 in context, that there is a mandatory rule previously in 4, and in the context of the cases which say that the derogations are to be construed restrictively, a construction that gives a permission to derogate from a mandatory rule in every case is a most unlikely proposition. And it is not Calfellis. And the second point I would submit is that it's not a natural submission on both domestic, but also I would submit EU principles of liability. And I would submit there that both domestically and in EU jurisprudence, there are actually 3 categories of potential civil matters: contract, tort, and restitution. Now, in my submission, that is clearly the case. That is clearly the case in English law. But in this respect, English law reflects EU analysis. And for that, may I invite you to look at the case called Gaz de Zaghi, which is at page 1756. That is OA, Other Authorities 3, tab 64. Now, I'm here...
I wonder if perhaps, well, it just occurs to me, another way of, rather than relating 7.1 and 2 to 4, one might say that if 7.1 and 2, if you take Calfellis literally, then 7.1 and 2 would render the rest of 7 redundant. And indeed, a great deal else besides, I suspect.
My lord, that's an even better point than the one I made, and I adopt it. But yes.
Been thinking about that.
Yeah.
Yes.
In other words, if my learned friend were right, you'd only need one rule.
Yeah.
Contract, place of performance; tort, place of harm. Forget the rest.
Contractual liability is 7.1, all other liability is 7.2.
Yes. Which is what they've done in Rome, and I'll come to that, as to proper law, but they haven't done it in Brussels. Can I move? Can I revert to the submission I was going to make, which is that that certainly in English law and in EU jurisprudence likewise, there is no exhaustive bipartite dichotomy such that everything must be a matter relating to contract or a matter relating to tort. Whenever I say tort, please read me as saying tort, delict, or quasi-delict. And the Gaz de Zaghi case, if I said 1755, that is because that is the beginning of the Advocate General's opinion on whether restitution on ground of unjust enrichment is a matter of tort delict or quasi-delict. And in this case, in this case, the court did not deal with this point. And so the Advocate General's opinion didn't have to be considered by the court because it was held that it wasn't a civil and commercial matter, because it was a matter of fines, or analysed as a matter of repayment by way of restitution for fines which had been levied in too large an amount. So I'm not saying this is ratio, but I am inviting you to read this for the purpose of my submission that EU jurisprudence recognises a three-way division of civil rather than a two-way. And so at page 1755, Advocate General, paragraph 55, he puts the question. And then over the page at 1756, paragraph AG 60, having quoted Article 53, he says that it follows from this that the rule on special jurisdiction laid out in Article 5.3, and that's now 7.2, requires the occurrence of a harmful event giving rise to damage, in other words, a loss. Now, I'll be relying on that later on, but this is the distinction that I'm drawing to your attention. By contrast, an action for restitution on the basis of unjust enrichment is not based on loss. The regulation doesn't contain definition of restitution or unjust enrichment, and he ventures to describe it in the following terms. And essentially, he reproduces the familiar distinction in English law between a loss-based remedy and a gain-based remedy, and says that what restitution is a gain-based matter, and what tort in 5.3, now known as 7.2, is dealing with loss-based compensation. So in the middle, just this passage, I invite you to read it yourself quietly, but just this passage. Unlike an action which seeks to establish the defendant's non-contractual liability, which aims to undo loss or damage, and so on, an action for restitution based on unjust enrichment aims to restore the applicant a benefit which the defendant has acquired illegitimately at the former's expense. As essentially argued by the German government, restitution on the grounds of unjust enrichment therefore inherently focuses on the gain acquired by the defendant rather than the loss suffered by the applicant. So my submission is that is the English law analysis, and Welsh, and that is also the EU analysis. And gain-based is different from loss-based. And the point about Calfelis is that it was considering only loss-based compensation or loss-based liability. Now, I'll come back to Calfelis after I've gone to Kleinwert, but may I then go to Kleinwert? And in short, my submission is that this decision of a strong House of Lords is impeccable and unassailable and right, and should not be reversed pursuant to the...
I don't think that there is any concept of a weak House of Lords. I would like to urge all counsel to avoid calling any court strong, because by implication it is criticising all other courts.
What I meant was that Lord Gough was particularly interested in restitution.
Well, we can work that out for ourselves.
We are convening a 7-judge panel to look at another aspect of Climate Benson next year, but not the aspect that you're concerned with.
I know it's not my...
It's to do with limitation.
Is it the contract?
It's the question of how the limitation provision operates, whether with reasonable diligence you could have spotted the mistake in a Kleinwert situation.
I see. Because one of our submissions, and one of my submissions I repeat, is that if there's anything wrong with Kleinwert, as applied to this case, it is that they should have held it was a matter relating to contract. They held it was a matter not relating to contract nor tort. My learned friend says they were wrong about the tort leg of that. But as we may well see tomorrow, in some of my friends' submissions about contract and cases such as Profit and Ossie, if, and I am not saying there is, but if any criticism is to be made of Kleinwort, it is that they should have said contract, not that they should have said tort. And of course, my learned friend would then lose this part of the appeal. Whether he could start again under the contract head is not a matter for here. Page 655, PA1. In tab 7 of PA1, 655 is the beginning. 674 is Lord Gough. And in Lord Gough, at the letters, between the letters C and D, he says the argument, which is my learned friend's argument now, is impossible to reconcile with the words of Article 5.3, if only because a claim based on unjust enrichment does not, apart from exceptional circumstances, presuppose either a harmful event or a threatened wrong. The argument was based on a misreading of paragraph 2A of the court in Calfellis, a misreading which is plainly inconsistent with paragraph 2 of the same ruling. And so I'll take you to 2A and 2B, but that's where the key of the case lies. At page 679, just at the letter F, Lord Nichols agreed with Lord Gough, Lord Clyde and Lord Hutton. At page 687, Lord Clyde, at the letters C to D, referred to a passage of the Advocate General Darmon in Shearson. Now, I'm not going to take you explicit to you that, but that's in the supplemental bundle in tab 1. And then where he construed a passage in the judgment of the court in Calfellis, para 18, as enabling a claim for unjust enrichment to fall within Article 5.3, it is evident that the argument depends on an imprecise translation of the passage in Calfellis, and properly understood, the judgment does not support the suggested conclusion. The basis then disappears. Now, then at page 698, Lord Hutton gave the most reasoned on the point. And it's at the letter A at page 698. Kleinwort submitted in the alternative that fell within 5.3. 4 lines further down, in my opinion, it would be inappropriate to apply the words where the harmful event occurred to a claim for unjust enrichment. And then it's this, he considers Calfellis. I consider that the judgment of the European Court in Calfellis operates to strengthen the submission of Glasgow that Article 5.3 is inapplicable, rather than to assist the argument of Kleinwort. And we will see this in Calfellis in a minute, but in that case, question 2 referred to the court was in these terms at page 5569. Now, that is reproduced at page 957 of the electronic bundle. It's not exactly page 5569, it's page 5582 at electronic 957, but it is the same question. Must the term tort be construed independently? And so question A is it independent, or is it an EU autonomous meaning, or determined by the private international? And then question B, does Article 5.3 confer in respect of an action based on claims in tort and contract and for unjust enrichment, his lordship's emphasis, accessory jurisdiction on the account of factual connection, even in respect of claims not based on tort? Now, as we'll see from Calfellis, on the same facts, the claimant brought a claim for breach of contract, for tort, and concurrently for unjust enrichment. And against that background, question 2B was, does Article 5.3 confer, in respect of an action based on claims in tort and contract and for unjust enrichment, accessory jurisdiction on the count of factual connection, even in respect of the claims not based in tort? And even in respect of the claims not based in tort means, or includes, the claims based in unjust enrichment. They considered that question at 14 to 21, some of which my learned friend read, and the answer is at page 962 of the electronic bundle. The term matters relating to tort, and then in the next line, must be regarded as an independent concept, covering all actions which seek to establish the liability of a defendant, which are not related to contract within the meaning of 5.1, now 7.1. But it's the answer to B that actually is relevant to this case and that case. A court which has jurisdiction under Article 5.3, as did the court in Calfellis, and as does the court in this very case, because it's been found, subject to Article 14, that the commercial court in London has jurisdiction over the tort claims here. So I read again, a court which has jurisdiction under Article 5.3 over an action insofar as it's based on tort, that applies to this action, because the Court of Appeal so found and we haven't appealed that, does not have jurisdiction over action insofar as it's not so based. I.e., in a case where you can bring your claim in tort and restitution, the fact that you have jurisdiction under the tort head does not give you jurisdiction under the restitution, for the restitution claim. And Advocate General Darman and the misreading was to misread 2A as the operative question and misread 2B, and that is the point made by Lord Gough, Lord Clyde, Lord Nichols, Lord Hutton, and as we'll see, many subsequent advocates general. That leaves question 2A, which was actually, the question 2A was actually asking something completely different, which is, do you apply an autonomous meaning, or do you refer it to the private international? But the Court of Justice there chose to add the words, actions which seek to establish liability. And what Lord Hutton says, again, I submit rightly, I agree with Mr. Justice Hurst that the word liability in answer 2A must be interpreted as meaning liability within the scope of 5.3, namely tort, delict, and quasi-delict. And the court, in answer to question 2B, is stating that a court which has jurisdiction under Article 5.3 over an action, insofar as it's based on tort or delict, does not have jurisdiction over an action, insofar as it's not based on tort or delict, but based on unjust enrichment. And that is my submission, the only, but certainly the better reading of Calfellis. Now, the question then is, what do we know about this misinterpretation or this loose translation or something of that nature? Fortunately, in the bundle at electronic page 1183 to 4, in the argument in Agnew, all is made, I would submit, clear. OA, so that's OA1 tab 40. The case starts at 1174, but it's 1183 to 1184, yes, the electronic bundle that I'm relying on. This was a case in which it was held that a claim by an insurer alleging failure to disclose material facts in relation to an insurance policy was not a matter relating to tort. That was the ultimate decision. And I rely on it. It's in writing. I won't take you to the passages immediately, but they're at 1210 to 1218. It held not tort because there's no loss claimed and there's no claim for damages. So that supports the general proposition that to be a claim in tort, there must be harmful event and must be damage. But for present purposes, so far as light can be thrown on Calfellis, 1183 of the bundle, we have the argument of Mr. Cybery, QC, in reply at the letter D. And rather more diligently, I'm afraid, than has been done in this case, at page 1184, he gets to the bottom of it. Under the letter A, as regards Article 5.3, the fact that the claims do not fall within Article 5.1 raises no presumption they fall within Article 5.3, and so on. Then at the letter C, to hold that the plaintiff's claim fell within Article 5.3 would be contrary to Calfellis. And then it's this between C and D that helps. The German text of the report of Calfellis's case, German being the language of the case, uses the word Schadenschaftung, which means a liability in damages. Liability in this context means liability in tort delict or quasi-delict, Kleinwort-Benson, 196F, which is Lord Hutton. It's clear from Calfellis and Reichert's claim that a claim cannot fall within Article 5.3 unless it is a claim seeking to establish the liability of the defendant in respect of damage that the defendant's tortious, delictual, or quasi-delictual conduct has caused. The plaintiffs are not seeking to establish the liability scienter, meaning in damages, of the defendants in respect of damage caused by the tort. On the contrary, they seek to establish their own non-liability. It was a claim. So it's question 2b is the one that matters here. And the answer to question 2a, which went beyond the terms of the question in referring to liability, means liability for damages. And that's what...
Sorry, what did Lord Nichols say about this? Did he?
He said liability in tort, he said. Liability in 2a must mean liability in tort. That's page... is 196 of the report. I will... it's page 698 of the bundle, sorry. I agree with Mr. Justice Hurst that the word liability in answer 2a must be interpreted as meaning liability within the scope of 5.3, namely liability in tort, delict or quasi-delict. Now, the translation would say liability in damages, which is slightly different. And perhaps if one goes back to 687, in the judgment of Lord Clyde, in my submission, that is the imprecise translation that he's talking about.
687?
687 of the electronic bundle in Lord Clyde. The imprecise translation is of Schadenschaftung as liability. The precise translation would be liability in damages. And of course, going back to the EU analysis, that's once again the loss-based claims rather than a gain-based claim. Now, if we go to Calfellis, that is borne out. Calfellis is at the Principal Authorities Bundle, tab 27, electronic page 954.
Sorry, the reference again.
954, sorry. That's the beginning of the judgment. And then at 957, a reference that I gave earlier on, but here made good. 957 is the question referred, or are the questions referred. And 1A was, 1 doesn't matter for the present purpose. So it's 2A, must the term tort be construed independently, and so on. And then 2B, does Article 5.3 confer, in respect of an action based on claims in tort and contract and for unjust enrichment, accessory jurisdiction on account of factual connection, even in respect of the claims not based on tort? Then at judgment paragraph 14, they repeat that formula, page 959 of the bundle. They repeat that formula in the secondly. I won't read it out, but it's a repetition of the substance of the question. And then in paragraph 17 is the answer to question A, where the liability comes in. That's the imprecise translation. And then in the answer at 962, one has the answers that Lord Hutton quoted. And the difference between question 2A and question 2B, and the words does not have jurisdiction over that action insofar as it's not so based. So that is just to identify that Lord Hutton was not mistaken in his analysis. And before we leave that, can I just go back to 956 to show you the nature of the claim in Calfellis? Paragraph 3 of the judgment. It was loss of investments in a stock market context, but halfway down, Mr. Calfellis' claim is based on contractual liability for breach of the obligation to provide information, on tort pursuant to a part of the German Civil Code, since the defendant caused loss, contra bonus mores. He also alleges unjust enrichment on the grounds that the future stock exchange contracts are not binding on the parties by virtue of mandatory provision of German law, and therefore reclaims the sums he held over. So the result in the case was that cause of action number 3 was not within Article 5.3. So here, just because my learned friend can get the tort action going for his damages for misrep claim, he can't get jurisdiction under 5.3 for his restitution claim. And if he were right, the answer to 2B and the result in Calfellis would have been different. Now, my learned friend cites cases after Kleinwort, and they are, if I can just recite them, they are Universal Music at page 1091, Brogsitter at page 875, Löber at page 969, and Granarolo, that's the only one he read, at page 1789. In all of those cases, all the European Court did was to recite Calfellis in each case for damages for tort. So one was a case for negligent drafting by a lawyer, compensation for damage, tortious breach of a duty to work exclusively for an employer plus breach of trust, that's Brogsitter. Löber was a misleading investment prospectus causing investment which was then lost, just as was Calfellis. And Granarolo was the tort of wrongful termination of a long-standing business relation. So they don't take the matter any further. They are all cases where the liability claimed was a liability in damages, where there was a harmful event. By contrast, the point was adverted to, and helpfully in my submission, in the Austria against Amazon case at page 851. That's Principal Authorities Bundle, Volume 2, tab 21. And the passage, if I may, I will take you first to the judgment in page 43 to see what it was about, and then back to the Advocate General. So page 873 of the bundle, paragraphs 42 and 43 describe the nature of the claim. In the present case, the action brought by Ostro Mechanica seeks to obtain compensation for the harm arising from the non-payment by Amazon of the remuneration paid for by the relevant statute. And 43, in that connection, it must be recalled that the fair compensation referred to in the directive, according to the case law of the court mentioned in 19 of the present judgment, intends to compensate authors for the private copy made without their authorization of their protected works, so that it must be regarded as compensation for the harm suffered by the authors resulting from such unauthorized copy by the latter. So the nature of the claim in this case was compensation, claim for compensation for unauthorized use by Amazon of protected work without authorization. And it's Advocate General at page 863. The Reverend Secretary starts at 862, but at 863, in paragraph AG 63, agrees that the claim here concerns matters relating to tort.
Sorry,
And
which
then,
paragraph are you, please?
AG 63,
Thank you.
page 863, I'm sorry. Too many 63s here, but then 65, I'm not warranting that that things I don't read are irrelevant, but I'm just highlighting the bits that I want to rely on. Article 5.3 of the regulation confers jurisdiction to entertain claims relating to tort, etc., where the harmful event occurred or may occur. It follows from this wording that a claim relating to tort, etc., must necessarily be based on a harmful event. Be based on, not exist in circumstances where coincidentally there is one. In this regard, the court held that liability in tort can only arise on condition that a causal connection can be established between the damage and the event in which that damage originates. It is also stated that the event giving rise to the damage represent all elements which give rise to liability. And can I invite you to look at the footnote 17 there, which is the Beer de Mines de Alsace de Potasse case, which says that in this tort, Article 5.3, now 7.2, it is essential to establish a harmful event causing damage. So that's two elements within 7.2, formerly 5.3, which are necessarily harmful event and damage. Then going back to Attorney General 67, it follows that a claim seeking to establish liability of a defendant within the meaning of the case law and so on must be based on a harmful event. That is to say, an event attributed to the defendant which is alleged to have caused damage to the other party. And then he reverts to that at the bottom of page 863. In my view, it follows from the foregoing that the harmful event, and so on and so forth, consists of the fact that Amazon, EU, and others failed, deliberately or negligently, to pay the levy, thus causing damage to Austro-Mechanica. And then over the page, 864, at AG 75, the case of this type is absolutely quintessential instance of a matter relating to tort, given that the refusal to pay the remuneration caused damage to Austro-Mechanica. Now, in that respect, then we have page 871 of the bundle, paragraphs 31 and following of the judgment. And page 31, they identify that in matters relating to tort, the courts of the place where the harmful event are usually the most appropriate for deciding the case, in particular on the grounds of proximity and ease of taking evidence. Now, I can't remember who it was that asked the question, but I think it might have been Lord Hodge, but forgive me if I'm wrong. What is the justification for a differentiation between tort and unjust enrichment? And it's here associated with that of the Advocate General, which is that in the case of tort, because there is, we would submit damage, well, there's a harmful event, the place of the harmful event is most appropriate, in particular on grounds of proximity and ease of taking of evidence. But that is not necessarily the case in a gain-based restitution claim, because in a gain-based restitution claim, exemplified by this one, you have two places with equal claim. My learned friend would say, I, the insurer, made my mistake in London, but my client, the bank, may well say, well, I, the bank, made my gain in Malta. And so the justification for providing 7.2 for tort, but not providing something equivalent for restitution, is that there is not so strong a connecting factor as there is in tort the connecting factor in tort being that the place of the harmful event is the place where all the evidence will be. That's to answer the question that my learned friend tried to answer.
I see we can also see in paragraph 29 another proposition which my Lord Hodge was suggesting earlier, that the rule in what's now 7.2 must be interpreted strictly.
Yes, I rely on that also. I think, to be fair to my learned friend, he didn't dispute that there were many cases saying that.
I mean, this court discussed this matter, I think, in AMT and Marsilia, discussed the harmful place and the place where the damage occurred and the rationale behind that 2 or 3 years ago. Anyway.
I don't have that one in mind.
Yeah, I noticed. That's why I mentioned it.
but my submission is that there are rationales in tort which don't apply in gain-based restitution.
My recollection is we discussed those rationale in the tort rationales in AMT.
I hope they were or included proximity in the ease of taking evidence.
My recollection is they did.
Okay, well, I've got at least one case that supports that submission, if not perhaps the better one.
And you go so far as to say this is Act Clare?
I do. And I've got another submission on that, which is that it's Act Clare in all the states of the Union of which we know, and I'll come to that in a minute. Sorry. Actually, all I want to do is note that 872 in Ostro against Amazon, para 32, according to settled case law, the concept of matters relating to tort covers all actions which seek to establish the liability of the defendant and do not concern matters relating to contract within the meaning in Calfelis. And once again, one sees the European Court citing Calfelis word for word without interpreting what that liability means. And I've made my submissions on that. But it's at the bottom of page 872, paragraphs 39 and following, or perhaps, yeah, paragraph 39, page 872. It must be determined whether a claim such as that at issue in the main proceedings aims to establish the liability then within the meaning of 32. Such is the case where a harmful event within the meaning of Article 5.3 may be imputed to the defendant. And this, liability in tort, can only arise provided that a causal connection can be established between damage and the event in which that damage originates. See Beers de Mines d'Alsace de Potasse. And then over the page they say this is such a case because it is in effect a claim for compensation for unauthorized use of the copyright of the protected materials. Now that is inconsistent with my learned friend's case because his case, as we'll see when I come finally to what his case is and what his case has been found to be, does not require, or this part of his case does not require any harmful event. Actually, but before I do that, can I go to the Gazda Zaghi case, which is page 1743. That's Other Authorities, tab 64. Other Authorities 3, tab 64. Uh, 1743 is the beginning of the report, but the passage I would invite you to look at is at the page 1757. I've already read this AG 61 at 1756. I've already read, when inviting you to accept that there's a three-way distinction in European law. But it's 1758 that, for present purposes, And in answer to my Lord Kitchen's question, is it I would invite you to look at. AG 66 at 1758, he refers to the view of Advocate General Darman, and he says it's not necessary to give a ruling on that question. AG 67, for the sake of completeness, I would add that several Supreme Courts of the Member States have held an action based on restitution for unjust enrichment not to involve a matter of tort, delict, or even quasi-delict. Unsurprisingly, commentators have also been reluctant to classify claims in restitution per se as claims relating to non-contractual liability. And then there are, at 43, there's the House of Lords, which I'm inviting you to uphold, but Kleinwort-Benson seems to have been followed, or at least the same result achieved in Austria and Sweden, I think. And as far as research has indicated, there are no dissentient Supreme Court decisions going the other way. So I suppose if 3-0 can be said to be acte claire, then it's acte claire, but it is on analysis.
The House of Lords presumably thought it was that clear 20-odd years ago.
Yes. No? No, I'm told. Mr. Board tells me no, because a reference was applied for under the then obtaining procedure, and the court in Europe said that because it was an intra-UK matter between the Glasgow City Council and the bank in London, it wouldn't apply. So,
I persuaded the court that it was inadmissible. We wouldn't be here.
I'm very grateful to Mr. Board for saving me from a false submission that could have been so quickly refuted and convincingly. Where was I? Gazdazagi. I think I got to the end of Gazdazagi. Yeah. Can I then just, for the sake of, before I come to submissions about Rome 2 and other harmful events, identify for the court, I've made submissions as to what the test is. The test is that for a harmful event, for tort, you need a harmful event and loss and damage. That Calfelis doesn't mandate the dichotomy, as it were, that Kleinwort-Benson is right and followed wherever it's come up. And I would now like to just identify the nature of the claim against the bank relevant for present purposes.
I mentioned AMT, it's 2017 UKSC 13. It was on Article 5.3 of the Proceeding Convention.
I'm very grateful.
Proceeding Regulation, sorry.
And
2000 regulation.
And may I pray what used to be called the locus penitentiae to come out to it? Yes, this may not be controversial, but it may be because if you look at my learned friend's case, which is page 183, also known as Core Bundle CV1 tab 6. I don't know if this submission is maintained, but
Sorry.
if I'm told it isn't maintained...
Which paragraph, Mr. Bates?
Sorry, para 64, I beg.
Thank you very much.
Dealing with Kleinwort-Benson, and the submission is that if there is to be any limitation on the court's jurisdiction in respect of restitutionary claims under 7.2, it is that the claim must arise from or in connection with a harmful event, Kleinwort-Benson. Then it's 2 lines further down. However, many claims for restitution, and these are the words, such as the claim in the present case, do presuppose and are based on the harmful event. In the present case, of course, there was a harmful event. Well, there was a harmful event, but my submission is the restitution claim is not based on that. And the plea, I just refer to the pleading at page 367, but the pleading is a simple mistake pleading, paragraphs 70 and 71. But insofar as the analysis of that plea is material, the judge and the Court of Appeal both found that this part of the claim was based on simple mistake, and although there may have been a harmful event in his tort plea, this part of the claim was not based on it. And can I just identify those paragraphs of the judgments for you? It's the judge at paragraph 78 at page 339. Two-thirds of the way down that paragraph, after the citation of Cal Fellis, the claim for restitution in this case is based upon a mistake. It does not require a harmful event, though there might in fact be one, as suggested by Mr. MacDonald Eggers. And that's how the court analysed the claim. And then the Court of Appeal, at page 315, of the same bundle, paragraph 145, his lordship recites my submission. Kleinwort Benson was binding. In any event, it was correct. The restitution claim here was based simply on mistake. It was not based on a wrong, and that is the submission I'm now remaking. A discussion on conclusions. The issue can be taken very shortly. I'm not persuaded that we should interfere with the judge's characterization of restitution claim. In this case, is based purely on mistake. Now, one of the remedies that my friend may want to seek for his damages claim may be rescission for misrepresentation, but he can claim for damages, if he likes, in the he can claim that relief as part of his tort claim in this jurisdiction if he's otherwise right about tomorrow's agenda. What this is concerned with is the claim independent of the tort claim, based on mistake, which my friend needs if my client is not to be held vicariously liable, to use perhaps a slightly inaccurate phrasing, for the misrepresentations made by the owner. So this part of the case is only relevant to his non-wrong-based restitution claim. And that is what the judge and the Court of Appeal were saying, and that is what is in the pleading at paragraph 17. Can I then come to Rome 1 and Rome 2? And the point my learned friend makes here by reference to the Ergo case and the article by Professor Briggs, and the submission here, essentially, I may mis-summarize it, but this submission here essentially is that the Rome 1 and 2 conventions do draw an exhaustive dichotomy between matters, well, between contract and non-contractual obligations. So far, one might say, what impact can that have? But the answer is that the recitals to the Rome Conventions both say that this regulation should be consistent with the Brussels regulation. And can I show you that at page 901 of the bundle in the Ergo case? So that's principal authorities. 223, and the case starts, I should say the case starts at 882. But it's 901 of the bundle that I would start with. And it says, according to recital 7 in the preamble to Rome 1, the substantive scope and the provisions of this regulation should be consistent with, essentially, the Brussels regulation. And the argument, based on Professor Briggs' article, is that that means the Brussels regulation should be changed to be consistent with, or to be brought into line with the Rome regulation. But the simple point is that that is not what this is saying. This regulation should be consistent with. And in any event, the Brussels regulation, what the court held was not that the Brussels regulation should be read in this way. And one sees that from 909. I won't read these out, but paragraphs 43, 44, and 45 are dealing with the concept of the non-contractual obligation within the meaning of the Second Rome Convention. It must be recalled that the concept of matters relating to tort delict and quasi-delict within the meaning of 5.3 of the Brussels I regulation include all actions which seek to establish the liability of a defendant and are not related to a contract within the meaning of Article 5.1 thereof, see OFAB and the case law cited there. Furthermore, it must be observed, as appears from Article 2 of the Rome II regulation, that that regulation applies to obligations ensuing from damage. So that is to say, any consequence arising out of tort, delict, unjust enrichment, negotio, gestio, or culpa in contrahendo. In the light of the above, non-contractual obligation must mean to be an event which derives from one of the events listed in Article 2 of that regulation. So they are not saying that events relating to damage, they are not saying that events not relating to damage should be retrospectively construed in the Brussels regulation by reference to the non-contractual obligations in 45, because the non-contractual obligations in 45 themselves ensue from damage. What they're saying is that the Rome regulation must be read to comply with the Brussels regulation to report the requirement of the damage. And my friend stands it on his head, I submit. But in any event, that is a matter of construing the Rome regulation, not the Brussels regulation, and we are here concerned with the Brussels regulation. And I was going to submit that the fact that there was a harmful event is immaterial, except to the extent that my learned friend's case is based on it. But I think I've made that submission. So, subject to that, that those are my submissions on issues 1 and 4, unless there are questions.
I don't see any further challenges to what you have to say. Thank you very much, Mr. Berry. Mr. Port? I think you've got about a quarter of an hour.
I do. I have a number of points to make, my lady.
Yes, of course.
Just on the questions of fact, which my learned friend referred to, in relation to the letter of authority, I mean, I'll just repeat what I said before. Mr. Justice Tier did find that the letter of authority was presented to the insurers by the owners on behalf of the bank, and the reference for that is Mr. Justice Tier's judgment at paragraph 31, PA2, tab 7E, page 330.
CV2, not PA2.
Sorry, CV2, not PA2, I'm so sorry. And of course, it must be remembered that it was also attached to the settlement agreement, So all that the courts below found was that the owners, when they made their claim, did not do so on behalf of the bank. But that can't erase the fact that this letter of authority was presented to the insurers on behalf of the bank. And of course, the fact that it was attached clearly meant that the insurers would not have paid without that authority, not least because the bank was the only person who had was entitled to payment as sole loss payee. My learned friend also referred to the European Court's decision in Pelu, which is Primary Authorities 2, tab 30. And it's important in that case to recall, if you could, I ask you to turn it up, PA2, tab 30, pages 1048. And the important points to draw, and it's basically 1048 to 1051. And I would ask the court to consider paragraphs 34 to 43. But there are two grounds of distinction in relation to that particular case. The first is it was concerned with Article 12, sub-Article 3, which was a concern given its impact upon weaker parties. And that's not the provision which we're concerned with in this case. We're concerned with Articles 15 and 16, insofar as the insurance section might be relevant, that is. But the second point to bear in mind is that this was a case where the relevant subsidiary was identified as an insured or beneficiary in the policy itself, and the contract of insurance was made on behalf of those subsidiaries. Whereas the principles we've been considering, by reference to the other authorities and, for example, the opinions of Professor Briggs, is that, and Mr. Joseph, is where there is a contract which includes a jurisdiction agreement, and a third party, not an original contracting party, but a third party, succeeds to either rights or obligations under that contract. And so the relevant consent, following the decisions, for example, in Tilly Russ, is supplied by the original contracting parties to the contract. My learned friend also referred to the Tilly Russ in identifying the fact that that was a case concerned with the transfer or assignment of rights and obligations. But the important point to bear in mind is that this was the issue as to the transfer of rights does include an obligation to, for example, comply with a jurisdiction agreement, insofar as that is relevant to the right being asserted. This is the conditional benefit principle. And it's for that reason that Mr. Joseph, in his book, and also Mr. Justice Moore-Bick in Glencore and in Metro against Glencore, which is referred to by Mr. Joseph, identified the fact that it doesn't have to be a transfer of rights and obligations. It's sufficient for it to be a transfer of rights, but subject to the conditional benefit principle. So if I transfer a right to a third party to exercise, for example, a right to payment under a policy, that would inevitably be subject to the condition of the choice of law and jurisdiction agreement in the policy itself. And that's what Mr. Justice Moore-Bick in Metro and Glencore was concerned with. And just for the court's reference, the decision of Mr. Justice Moore-Bick is at PA1, tab 3, pages 604 to 606, where Mr. Justice Moore-Bick considers the starting point in Tilly Russ with the transfer of rights and obligations, and then goes beyond and says, but this principle still applies in the case of a transfer of rights. My learned friend's reference to the Pan-Ocean decision is, we would say, is a consideration of the conditional benefit principle, but it's concerned with a very different factual scenario. There, the question was not whether the person claiming entitlement under a contract is subject to a jurisdiction agreement, but whether or not it also imported an obligation to repay as a matter of contract or as a matter of the law of restitution. And that was the issue in that case. It wasn't anything to do with jurisdiction. Whereas in all the cases we've looked at, the conditional benefit principle has been applied to jurisdiction agreements altogether. And the only issue is, in this case, is whether that condition is satisfied by something less than the enforcement of a claim by litigation, by the commencement of proceedings. Whereas an assertion of right, is that enough? My learned friend relied upon the Court of Appeals judgment in the J. Bowler, which identifies the principle of the condition and benefit principle by reference to asserting rights inconsistent with the jurisdiction agreement. Now, we say that's fine as far as it goes, but it's not the full extent of the principle. But if it were, in this case, the jurisdiction agreement, all it says is that the parties must submit to the jurisdiction of the English court. It doesn't say anything more. And so we would say that the submission to jurisdiction accompanies any assertion of right. It doesn't require suit. For example, the jurisdiction agreement doesn't say, in the event of suit, it must be subject to the jurisdiction of the English court. It just says the parties submit to the jurisdiction of the English courts. My learned friend said the logic of my submission is that somehow or other the bank, by making a single claim, would be liable to pay premium under the policy, bearing in mind that is a liability. That's not my submission. My submission is that when there's a transfer of rights, those rights are accompanied by any obligation in the contract which is relevant to that right. And we would say, we do not say that the payment of premium is such an obligation. This is not a case where we say that if you assert a right, suddenly you're subject to all the obligations set out in the contract of insurance. That's not the case. It's only the relevant obligation in this context is submission to the jurisdiction. And the additional point, I think earlier on I was asked, what's the practical purpose of this appeal? And I answered, I think, I'm proud of half an answer. My answer was, well, there are two causes of action, one here and one has to be pursued elsewhere. Of course, I ignored the other pertinent fact, which I did refer to elsewhere, was, of course, we're suing the owners in accordance with the jurisdiction agreement here, and therefore being required to sue elsewhere would, of course, mean that we have two separate sets of proceedings involving the same issues of fact, and that's not something which can be solved by a modification of the party's position. So with that, that's all I wish to say on issue one. Oh, yes. The only other point I think I ought to make is that it is relevant to note when one is speaking about a third party, whether it's an assignee or loss payee, asserting rights, and therefore we say subject to certain conditions attaching to those rights. It is important to bear in mind the assignee should never be in a better position than the assignor. That's the whole nature of the assignment of rights. So by having the right to payment or under a policy assigned, but in some way evading the submission to jurisdiction, and it's not just a submission to English jurisdiction, it's a choice of law clause which informs the content of the right itself. By in some way allowing the assignee not to be subject to that jurisdiction would put the assignee in a better position than the assignor. And that's contrary to the notion of derivative rights under assignments, but also under the 99 Act. Now, I propose to go on to issue 4, unless there are any questions. No? Okay, as far as issue 4 is concerned, I do say Article 4, it's a mandatory ground of jurisdiction in relation to domicile, but Article 7 identifies additional permissive grounds of jurisdiction. I don't consider that Article 7.1 and Article 7.2, if they're construed in the manner I suggest, would somehow render the other provisions of Article 7 irrelevant, because they're dealing with further additional grounds of jurisdiction. For example, the location of cultural property, or whether or not, or the location of criminal proceedings which give rise to additional civil claims in restitution or damages. All that those provisions do is identify further grounds of jurisdiction, each of which are additional and permissive. So they wouldn't render those other provisions nugatory. They're still important. They still identify bases of jurisdiction. And therefore, my interpretation, I would submit, of Article 7.2 doesn't cause any difficulty in that respect. My learned friend relied upon the Advocate General's opinion in the Gazdazagi case, where the Advocate General obviously opined that Article 7.2 doesn't extend to claims for unjust enrichment. But at paragraph 66 of that opinion, which you can see at electronic page 1758, the Advocate General referred to Advocate General Darman's opinion in the Shearson Lehman case, which is, I think my learned friend gave you the reference, it's supplementary bundle tab 1, page 17, where that Advocate General expressed a contrary view, which is, based on Calfellis, Article 7.2 does embrace claims for unjust enrichment. And it is worth remembering that Advocate General Darman was the Advocate General in Calfellis as well. As regards the interpretation of Calfellis by reference to the questions put to the court, my lords and my lady, my lords will remember it's questions 2A and 2B. It is worth recalling, firstly, that whilst there were indeed claims in those proceedings for contract, tort, and unjust enrichment under German law, it's worth recalling the manner in which the answer was, question 2A was answered. And question 2B just refers to tort and delict. It's not unclear whether or not the court was intending to embrace issues of unjust enrichment. But the important thing I want to bear out, and of course this comes back to the issue of translation as well, if there were any uncertainty about my interpretation of the Calfellis decision, it hasn't been picked up in any subsequent decision of the European Court. Even with if, for example, the German translation was liability and damages, that's not something which has been clarified by the European Court on the many occasions when the Calfellis interpretation has been adopted. It's always been adopted using the same formulation.
It'd actually be useful to, perhaps, if somebody had looked at a German legal dictionary. But there are other people here who speak German better than I do, but I think Schaden would carry the sense of harm.
It does, but again, as I say, in the subsequent European Court decisions, that's not the meaning which has been carried through by the court. And if it really were an issue, it would have been identified. My learned friend referred to my lady, I've only got a few more minutes, so I hope that's...
Well, you are abusing the situation. I don't mean that in a pejorative sense at all, but you've already gone beyond the time allotted to you.
Oh, I'm sorry.
Yeah.
But, if I'm
but however, as we're not yet at 4 o'clock, I'm not saying go on till 4 o'clock, but I am saying if you've got a few more things to say, well, listen.
If you're about to close me down, I'd like to know with a few seconds' notice.
Oh, no, I'm not going to tell you. Yep. No.
All right. So my learned friend referred to the Austro-Meccana against Amazon case. Again, I would ask my lady and my lords to look at paragraphs 41 to 46 of the judgment. Again, for your reference, it's PA2, tab 21, page 872-3. That was it was an interesting case because that was a statutory an organisation collecting copyright pursuant to a statutory right for authors. So it itself hasn't suffered damage, because it wasn't its copyright, it was collecting it for authors. And the way the court concluded the matter was to say that the harmful event was not the breach of copyright, but the failure to collect the remuneration from Amazon. And that's not dissimilar to the case I'm about to put, because as I've said earlier, insofar as a harmful event is required, and it seems to be required under Article 7.2, we say, where you have a claim for restitution based on mistake, and that claim is based on payment of money, the insurer's money to the bank or the broker for the benefit of the bank, and that hasn't been repaid, that is a harmful event. It's been identified as a harmful event for the purpose of the misrepresentation claim. There is no logical reason why it shouldn't be regarded as a harmful event for a claim in mistake. It's a critical part of the cause of action that the payment out, and therefore the loss to the insurers, was itself by mistake. Without that payment out, there would be no cause of action. Therefore, that is a harmful event. But insofar as if that, in relation to rights of restitution which don't have that harmful event, for example, mere disgorgement of profits, in those circumstances, it's just as in the Austro-Meccana case, it's the failure to pay the restitution which can constitute the harmful event. And my last point, and I hope this is not entering the realm of abusing my privilege, but my last point is in the Ergo case, which is concerned with the correlation between Rome conventions and the regulations on the one hand, the Brussels regulations on the other. It is interesting that paragraph 45, which my learned friend read out, again, this is PA2, tab 23, pages 909 to 910, identified damage, but then went on to say that, so having quoted the Calfellis ground of interpretation of Article 5.3, said that the regulation applies to obligations ensuing from damage, but because that is to say any consequence arising out of tort, delict, unjust enrichment, negotiorum gestio, or culpa in contrahendo. So it's not limiting itself to tort, it's extending to unjust enrichment, and it identifies damage as being any consequence. So for those reasons, I would suggest that the Calfellis decision should be interpreted in the manner my clients submit. And unless there's anything further.
Admirably done to make sure you concluded.
That's very kind, Maddie.
Yes, thank you very much indeed. I suspect that it would make a lot of sense for us to adjourn now so that we can have a clear run at the insurance point tomorrow. Is that acceptable, Mr. Berry?
My lady, I'm not going to demand 10 minutes now.
My lady, we'll come back to the court on
Yes.
the issue of preliminary reference first thing in the morning, if that's satisfactory.
Thank you.